Hello, I'm Adam Bloomberg, Senior Client Success Advisor here at IMS Legal Strategies. Today's discussion is gonna focus on something that can significantly influence case strategy, risk evaluation, and ultimately better outcomes. We're talking about expert witness strategy and the process behind identifying, vetting, and aligning the right experts in complex matters. If you're watching the recording of this broadcast, please like and follow us here on LinkedIn and also on our YouTube channel. Joining us today is Erica Evans, Senior Director of Expert Services, and leading today's discussion is my colleague, Marie-Petra Adams, Vice President of Client Experience. There you are. Handing it over to you, Marie.
Thanks, Adam. Erica, I'm excited to have this conversation with you today because I think locating an expert, it can be one of the least understood aspects of litigation. I think people often assume it's just about finding a professional with the right resume, but in reality, there's a much larger strategic process playing out beneath the surface. And you've brought us two case studies today that really show how nuanced this process can be.
Yes. Well, first, thank you for having me, Marie. I'm looking forward to the conversation as well. And you're right, every case is different. Sometimes attorneys know exactly the type of expertise they need. Other times they know the technical issue, the damages issue, or maybe a communication concern, but they're not sure, they haven't decided what type of expertise is best suited for the case. And that's where we can step in and help too. A large part of our role is helping litigators think strategically about those questions and even before the search process begins.
Right. I think it's an important distinction because it's not just about find me an expert. There's usually a broader, deeper discussion around the specific needs of the case, the type of expert that best fits that need, so what do those early conversations look like with the attorneys?
Sure. And the initial conversations are something that we refer to as the expert specification call. It's really an opportunity for the search team and the client to get on a call together. And initially, it's to understand the bigger picture of the case. So at least for us, what we like to know is a little more about the theory of the case, the technical issue, any vulnerabilities that exist, maybe what might confuse the judge, jury, mediator, arbitrator, whoever is involved in the case. And also what the opposing side may potentially argue, maybe what our client's position might be. So the key question becomes, what type of expert will actually help explain the issue credibly and clearly? Because what we find is sometimes the most qualified person on paper is ultimately not the best communicator.
Right. So that's why communication and presence become part of the strategy. It's not just about the credentials.
Right. Expert selection is typically equal parts qualifications, expertise, credibility, communication, but also relatability. An expert can have world-class credentials, but if they struggle to clearly or simply, talk through complicated issues, that can become a challenge quickly for our clients. So our team is tasked with, our researchers and recruiters are tasked with evaluating expertise, testimony history. Has this expert done this before? Have they testified before? Communication style, disposition, publications, and then maybe even most importantly, how they may present under pressure.
Right. Gosh. So let's start with one of the most unique case studies we've reviewed, because I think it perfectly illustrates how unpredictable expert witness strategy can become. So let's look at it. This matter involved a dispute over dinosaur fossils and questions surrounding fossil custody and ownership. Yeah. How did a case like this come to your team?
Yeah, sure. And this was one of my most favorite cases. It is super fascinating. We find that cases like this typically start because an attorney realizes that they're dealing with a highly specialized subject matter issue outside traditional industries. And for this case, the team needed someone who could address pretty specific questions, including fossil identification, fossil handling practices, ownership considerations, and then also standards within the paleontology and fossil community. And here, the challenge became who has the right combination of expertise. And so specifically, who has the right combination of scientific, practical, and litigation credibility. Because we can find someone knowledgeable about fossils, that's one thing, but finding someone who can explain those issues in a legal setting, that's entirely different.
Yes, and I imagine that the search also becomes much more investigative than people would imagine.
Oh, exactly. Highly specialized searches involve extensive vetting and outreach. And you can imagine that these experts are well connected in the industry, but they may not market themselves as someone who testifies and does expert work. So we find ourselves evaluating different criteria, including academic experience, what's their education history, what field experience, hands-on experience do they have. In research-based cases like this, we're also looking at potential museum or research affiliations. What's their speaking ability like? Have they testified? And also, can they take these highly scientific concepts and explain them to non-scientists? And one other thing I want to mention about this is with something like paleontology, what we find is sometimes strong opinions or disagreements can exist. And we really get a taste for this during the interviewing process when our clients have the opportunity to talk with the expert.
What I found super interesting about this example too is just how litigation just can pull from such unimaginable disciplines, like all over the place.
Yeah, no, that's right. And that's one of the things that we've learned in litigation. It constantly creates unusual factual questions. And again, the challenge isn't who's the smartest person in the field, it's who can explain whatever issue is involved in a credible, understandable way that's also directly relevant to the issues of the case. And judges and jurors and mediators, they're rarely specialists themselves, and it can be challenging, but an expert, they have to function like an educator.
Right, and we've talked about this before, that expert strategy is often about translating complexity, right?
Yeah, absolutely. And, no matter if it's fossils or dinosaur bones or engineering or medicine, the goal remains the same. And that's helping decision makers understand complicated issues enough so that they can make informed decisions. And that does require a lot more than just credentials. It requires communication and clarity and strategic alignment with the facts of the case. A good test for us is if the expert is able to effectively do this when they're on the phone with one of our recruiters, taking these highly specialized concepts and details and translating them into layman's terms in a way that the recruiter can understand, because the recruiters are not experts themselves.
Right, and then the follow-on to that is, assuming it goes to trial, is then the juror perceptions play a major part in that.
Yes, and as our jury consultants remind us that jurors are looking beyond just the opinion themselves, but they're looking to see if the testimony feels understandable and credible. And so jurors may be asking, does this make sense? Does this seem realistic? Can I follow how this conclusion was reached? And so, yeah, the strongest experts are able to explain highly technical concepts calmly, practically, and in an understandable way.
Fascinating. So let's go to the second study that you brought us. This takes us into a completely different world. It's the medical device patent litigation study. And I think this one is especially interesting because it combines technical engineering, medicine, and intellectual property strategy all in one case. So let's look at it. A firm representing the plaintiff sought an expert with patent search experience to opine on what constitutes a reasonable prior art search. Okay, so they were looking for an excellent researcher who had experience with prior art for medical devices, had preferably been employed at the PTO, and had testified in depositions and at trial. So what was so challenging about this one?
Sure, right. A lot of requirements for this one. And you're right, it was challenging. And we oftentimes find that mix between patent and medical device requires a very, extremely precise fit. And in this case that you are mentioning too, the attorneys needed someone who not only understood the medical device itself, but had the technical depth and communication ability that's necessary for patent litigation. And that can become very nuanced very quickly. The expert here needed to address different concepts, including device design, also engineering principles and FDA considerations. Also, you mentioned this, but they needed to have the capability to understand and do research into the prior art, while also, being able to talk through highly technical patent concepts. And credibility is critical because the audience may include, sophisticated individuals like counsel or consultants and judges who are dealing with this very detailed subject matter.
Yeah, and I think conflicts also play a part in when we're dealing with these types of industries. I'm sure you run into that.
Oh, yes, they absolutely can. And again, these people are typically well connected. That's what makes them good experts, but that can come with its own challenge. They could be connected to manufacturers or competitors, maybe tied to a company that has a relationship with those that are involved in the case, or even prior litigants. So conflict analysis is a major part of vetting. And ultimately, the expert needs to be understood by people who may not have an engineering or medical background. And one of the biggest challenges that our clients and trial graphics team deals with is translating highly technical concepts, simplifying them, but not oversimplifying them, whether that be in a Markman hearing or at trial.
Mm-hmm. And the outcome of that case?
Sure. The case was determined in favor of the plaintiff with a 9-figure verdict, and the jury found that the infringement was intentional, which opened it up for treble damages.
Wow. So the common themes that we see in these two examples, right, whether it's fossil identification, medical devices, and I know we do a lot of unique expert searches, I've seen them. The issue is often, can somebody explain complexity clearly and credibly?
Yes, and at the end of the day, effective expert strategy often comes down to clarity.
Erica, it's been fun, and thank you for your time today. Thank you for giving us a behind-the-scenes look at the expert search process.
Absolutely. Thanks, Marie. It's been great.
Adam, I'm sending it back to you.
Great conversation, you guys. Really appreciate your time, Erica and Marie. Thank you. And to everyone out there, if you're still here, you made it. Thank you so much for joining us for another IMS Elevate discussion. If you've enjoyed this conversation, please like and follow us here on LinkedIn and on YouTube. We'll see you next time. Thank you to our guests for speaking with us today. To discover how the IMS team can help give your case an edge, check out imslegal.com or shoot us an email at contactus@imslegal.com. For over 30 years and across more than 65,000 cases worldwide, IMS has partnered with trusted law firms and corporations throughout the litigation lifecycle, providing comprehensive expertise and technology to help clients solve complex challenges.